All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon, everyone, and welcome in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is file KSC BC 2023-10, the Specialist Prosecutor versus Sabit Januzi and Januzi&Bahtjari.
Thank you, Madam Court Officer. Now we'll ask the parties and participants to introduce themselves, starting with the Prosecutor's Office. Madam Prosecutor, please.
Good afternoon, Your Honor. For the Specialist Prosecutor's Office, my name is Taz Shahabuddin. Next to me is Josh Hafetz and John Devaney. And behind me are seated Fabian Unser-Nad and Marlene Yaya.
Thank you, Madam Prosecutor. Now I turn to the defense, starting with the defense of Mr. Januzi, please.
Thank you, Your Honor. My name is Mr. Thomas Gillis, Bar Association Ghent, Belgium, and I'm the special counsel for Mr. Sabit Januzi. Thank you.
Thank you, Mr. Gillis. And for the record, I note that your client is here present in the courtroom. Now I turn to the defense of Mr. Bahtjari. Counsel, please.
Thank you, Your Honor. My name is Hendrik Sietema, member of the The Hague Bar, representing as duty counsel Mr. Bahtjari, also present here. Thank you.
Thank you, Mr. Sietema. And same for the record, I note that your client is also present here in the courtroom. And I turn to the registry.
Good afternoon, Your Honor. Jonas Nilsson, Deputy Registrar, representing Registry today.
Thank you, Mr. Nilsson. And for the record, I'm Nicholas Guillou, pretrial judge for this case. On 9 October, I scheduled the first status conference in this case for today. My goal is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I would like to discuss the status of the SPO's investigations, the estimated amount of documentary and testimonial evidence the parties will bring to trial, as well as issues related to disclosure of supporting material to the indictment, additional material intended to use at trial, evidence material to the defense preparation, exculpatory evidence, and protected material. And then we'll also discuss about the procedure for disclosure, the redaction regime to be adopted in the present proceedings, and finally, any other issues that the parties wish to raise. I thank the parties for their submission, and I will invite them to present their views in a concise fashion about each item on the agenda that I will address individually. I remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go in private or closed session. So let's start with the general questions, as I mentioned in my scaling order. Before I give the floor to the parties, I wish to remind them of the general principles of disclosure in the legal framework of the specialist chambers. Disclosure is an inter partes process in electronic form and facilitated through the registry's court management system. Disclosure shall be a priority for the prosecution at this stage, and the parties shall disclose evidence of true relevance to the case and not the greatest volume of evidence. In view of the publicity principle, evidence is registered as public unless there are reasons to classify otherwise. The disclosing party determines the appropriate level of classification of evidentiary items on a case-by-case basis. I first would like to hear from the SPO on this first topic in the agenda, notably the status of its investigation, the type of evidence it intends to use in the proceedings, and how many witnesses it intends to call at trial. Madam Prosecutor, you have the floor.
Your Honor, just to address those issues in turn, Well, first, as an initial matter, I would just refer the court to the prosecution's submissions for the first status conference, which the Specialist Prosecutor's Office filed yesterday on 11 October. With regard to the ongoing investigation, there is an ongoing investigation related to this case, but it is limited in scope. That said, there may be additional evidence adduced as a result of that investigation. If such evidence is adduced, then it will be disclosed to the defense. Despite the limited ongoing investigation, the Specialist Prosecutor's Office does not foresee that this will in any way impede the speedy conduct of proceedings. And furthermore, we aim to complete the investigation during the pendency of the pretrial proceedings, which should be over the next 3 months. With regard to the scope of the case, the evidence for trial and the volume of the forthcoming disclosures, we anticipate in terms of volume will be relatively small, at least compared to other cases that have been before this chambers. In particular, regarding witnesses, the SPO currently intends to call 1 witness, but may add up to 2 more. And would ask leave of the court to include others to the extent that would be necessary in order to authenticate its documentary evidence for trial. Turning to that evidence, broadly speaking, we expect that the documentary evidence to be disclosed to the defense is going to include transcripts of witness statements, official notes from witness contacts, records from mobile telephones, call data records, reports, and potentially audio-visual material. And that is across the board. If Your Honor wishes, I can address each of the disclosure rules in turn.
Later, we'll address them in turn. So
I
just
see.
the general remarks now.
In that case, I believe, Your Honor, that addresses generally the scope of the case and the extent of the disclosures that the SPO intends to make.
Thank you, Madam Prosecutor. I note that you indicated that investigation would not last more than 3 months. That's the correct
Yes, you're
interpretation?
correct, Your Honor. We anticipate to wrap up early next year.
Thank you, Madam Prosecutor. Now, let me turn to the defense. And before giving the floor to counsel, I note that at this stage, both defense teams for Mr. Januzi and Mr. Bahtjari cannot provide any further detail regarding the steps they intend to take as regards the question raised in the agenda for this hearing, notably because disclosure hasn't started. So I will ask the defense for their submissions on what the prosecution just indicated, starting with the defense from Mr. Januzi. Mr. Gillis, please.
Thank you, Your Honor. This meeting started with Your Honor, you saying that disclosure should be a priority for the prosecutor's office. I think that's absolutely also in the rules and in the procedure, of course. And basically, that's what defense of Mr. Januzi's main concern. The time schedule that we had in the submission that we received from the Special Prosecutor's Office, the time schedule is really broad. The Special Prosecutor just 2 minutes ago said that maybe 3 months maximum. The time schedule that has been presented in the submission talks about, of course, the first delay we don't have any problems with, 8th of November. It's within the law, of course, 8th of November, the 30th day. And then the 2 other dates, 24th of January 2024 and 26th of February 2024. The defense of Mr. Januzi, for us, it conflicts a bit with what is said orally today, but also in the submission under margin number 21. I think that it's a limited case. It's a limited case, with not so much evidence will be presented, but we jump immediately from today until 26th of February 2024. We have an objection to that. Of course, some of the evidence will be presented today. We had a CD-ROM, CD, with which will be important. I think it's the interrogation of my client the 4th of October, which will be very interesting, and we will start immediately. But I think within the law, normally the rule, and I don't have to say 102.3, that normally such material and evidence should be disclosed in category 2 without delay. Without delay, that should be the rule. And within this, for the defense, with what we know now, and also by the special prosecutor said, limited in when we compare to other cases, limited case. I think jumping to 24th of January and 26th of February is for now, as such, on today, it's far too reaching. And of course, I'm not going to say something already about our submission on the detention on remand, but of course that is towards the time limit. That's an element that is absolutely vital for the defense. Those three elements I absolutely wanted to already remark for now. Thank you, Your Honor.
Thank you, Mr. Gillis. Mr. Sitema, please.
Yes, thank you, Your Honor. I would gladly support the words of my learned colleague on this subject. As you all know, with my client being held in detention, there is pressure on the case and the speed of the investigation, and with that, the speed of the disclosure. At this moment, like my colleague said, we have no supporting material or the material supporting the indictments. We only have the indictment itself. Also, as stated, we filed submissions on the detention of on remand. We also have to do that with our hands tied behind our back, so to speak. So also in that respect, we need disclosure of material as soon as possible. Considering that what we heard from the special prosecutor is that it's a limited case, not as big as all the other cases, then it seems a bit strange to us in this situation that the presented time schedule is even going so far as the end of November next year. So we would urge you to decide a disclosure in that manner, that at an earlier stage we would get our material so we could build up our defense and our submissions which we need to make in that respect. That's what I wanted to add to the words of my colleague at this moment. So basically the detention is the biggest argument for us to get our material as quick as possible. Thank you for this moment.
Thank you, Mr. Sitema. We are going to discuss about these deadlines in the next topic in the agenda, because we're going to talk about each category of material. But I've well noted your request to get the material earlier, so we will see what we all can get from the Specialist Prosecutor's Office. Let us now move to the second item of the agenda, which is the supporting material to the indictment, the so-called 1021A material. I take note that the SPO intends to disclose material falling under this rule by 8 November 2023. I also take note that part of the SPO's material under Rule 1021A may require protective measures, so I invite the SPO to give further submissions on the disclosure of the supporting material to the indictment, notably the overall amount of evidentiary material, whether translations into Albanian of witness statements whom the SPO intends to call to testify at trial have been finalized, and any other details that the SPO wishes to provide. Madam Prosecutor.
Thank you, Your Honor. I would like to begin by just stating that the Specialist Prosecutor's Office is also interested in speedy proceedings here. And while overall the volume of materials ultimately may be relatively smaller to other cases, it is also still the case that it is just not a matter of us collecting materials and turning it over, but there's also the issue of translations and review and the application of redactions and potential protective measures. And so it is with those additional considerations in mind that the SPO has proposed the various dates it has. With regard to the 1021A materials, the SPO has proposed to take the 30 days prescribed under the rules, which would provide us with a deadline of 8 November. But I'm also happy to place on the record now that we fully intend to make that disclosure in advance of that date, and as far in advance of that date as we can manage, so that the defense has an ability to begin a thorough review of the indictment's supporting materials. With that said, regarding what the materials consist of, we anticipate that there will actually be fewer than 30 items on the 1021A list. It will consist of 3 statements from the accused, including 2 statements that were given by the accused to the Specialist Prosecutor's Office last week, which are currently in the process of being transcribed, a process we are pursuing as speedily as possible. In addition, we will be providing the defense with a detailed outline which accompanied the indictment, as well as transcripts of witness statements, official notes from witness contacts, records from mobile telephones, and call data records, amongst others. These materials will need to be redacted, consistent with the forthcoming redaction regime, to be adopted by Your Honor. And beyond that, to the extent that the defense has any particular requests with regard to materials that have been identified as forthcoming 1021A materials, we are certainly open to having a dialogue about disclosure.
Thank you, Madam Prosecutor. I take from your submissions that we can anticipate disclosure before the 8th of November, probably at the end of October. Is it what I can read between the lines?
That is certainly our aim, Your Honor. The reason that we have asked for the full 30 days is, sometimes these translation processes can come across unexpected hurdles, but we will, as soon as is practicable, make those disclosures.
Would it be possible for you to disclose the evidence that do not need redaction first, so that the defense can start reviewing all these documents and disclosing the rest as soon as possible?
If Your Honor is referring to a rolling disclosure process, certainly we can entertain that.
Thank you, Madam Prosecutor. Counsel for the defense, do you want to say anything on this specific type of evidentiary material? Mr. Gillis?
Thank you, Your Honor. First of all, a small correction. The precise dates, as mentioned before, are the 26th of January 2024 for Rule 1021A. It was not the 26th. And in February, the 23rd of February 2024 for 1023. It has to be correct. Excuses for that. Secondly, very short, because I've already spoken about it and our concerns. But I'm glad to hear from the defense, and I count on that the loyalty of the Special Prosecutor's Office will be that way, that if there's any material, that we get it, that we can start working. And that would be also completely logic in the sense of margin 21 in the submission, that it's a limited case and that we want to speed it up. But speed it up, of course, in the sense that with regard to Article 6 of the European Treaty of Human Rights, with correct, that we can work in a proper way with time and of course in a thorough way. So that's all what I have to say, because Your Honor, I already did it before. Our main concern are the dates and basically the loyalty of the Special Prosecutor's Office, which will be there, I'm absolutely sure. Thank you.
Thank you, Mr. Gillis. Mr. Sitema, do you want to add something?
Thank you, Your Honor. I'm very much in favor of being presented the evidence by the Special Prosecutor's Office as soon as it is able to do so. I'd rather have it in, say, so to speak, bits and pieces than all in once. We have to discuss it. I have to discuss it with my client, and every time there is something material being presented, it gives me that opportunity. So it also helps build up the defense in a practical way. So I'm very much in favor of that, that as soon as something is available, that it be presented. Thank you.
Thank you, Mr. Sitema. Madam Prosecutor, the material supporting the indictment that is unredacted or that do not need redaction, can it be disclosed in the following days to the defense as a first batch? Because you proposed a disclosure on a rolling basis, which I support, but for the material that is ready, can you disclose this, I don't know, tomorrow or Monday or Tuesday?
Your Honor, I would just ask that we be allowed to review the redaction regime as it is ordered before committing to a date. I think I would have no problem making an initial disclosure under Rule 1021A by the end of this month, which would at least be in advance of the deadline we have now. Otherwise, I would ask to reserve on that particular commitment.
I know that you will do your best as long as I issue my framework decision. So let's now move to the additional material that the SPO intends to use at trial, which is the 1021B material. I take note that the SPO proposes to disclose additional material falling under Rule 1021B by 26 January 2024, or in any case, no later than 30 days prior to the opening of the SPO's case. I invite the SPO to give any further submissions on the estimated amount and type of material it intends to disclose, the reductions that will be required, and any other details that the SPO wishes to provide in relation to this category of evidence. Madam Prosecutor.
Thank you, Your Honor. I would begin by saying that the primary driver, as I see it, of the deadlines that the Specialist Prosecutor's Office has proposed with regard to this category of material is the fact that the investigation is ongoing, and we do anticipate receiving additional materials for review. And so that review is underway in order to identify Rule 1021B material, and we are certainly pursuing it as aggressively as possible. We anticipate, again, that it will include documentary materials along the lines of what is to be disclosed under 1021A, including records from mobile telephones, call data records, the addition of some audio-visual material. That said, the materials that we already have under review may require transcription, translation, redaction, and there is this question of new evidence that we expect may come in that would also require that additional process. And so it is with those considerations in mind that although, as my colleagues in the defense have noted, the ultimate volume may be relatively small compared to some of what this chamber has seen, the Specialist Prosecutor's Office was not comfortable coming up or committing to a more aggressive deadline than the one we have proposed for January of next year. That said, we are confident that we will be able to meet that deadline, and certainly, again, happy to have open dialogue with the defense regarding rolling disclosure and particular materials that they may be interested in.
Thank you, Madam Prosecutor. I turn to the defense. Do you want to add anything? Mr. Gillis?
Very short, Your Honor. I noted the Special Prosecutor not being comfortable with getting it earlier. I can only say, not being to you, Your Honor, not being comfortable is not the same as not being possible or not being prepared to do it. I think behind me, of course, there's an accused. For him, it's not is not being comfortable either. And with that I mean there is a pressure, like my colleague for the other defendant also has said, there is a pressure of the remand in custody, and not being comfortable for us, and that's with all the respect that I say that, Your Honor, for the defense of Mr. Januzi, that's not enough as an argument. And I really ask Your Honor to make their decision, bearing in mind I'm having margin 21 here in front of me, and the Special Prosecutor in the submission says that the relatively limited volume of material to disclose as compared to other KSC, but then, and in particular the nature of the disclosed material. So also the nature of it is not too complex. And for us it's really too far. So I do understand being not comfortable, I do understand that, but it's not enough as a legal argument for us. So we ask the defense, Your Honor, to look at that and rule that there must be a possibility. It's 3 months and a half. I think for 102(1)(b, 3 months and a half from today. That's too far, I think, in this case, that I wanted to add.
Thank you, Mr. Gillis. Mr. Sitema, please.
Thank you, Your Honor. I agree with the words of my colleague. I would add to that, may I suggest for you to set a more strict date for, or more strict time limit for the 102(1)(b disclosure than argued by the Special Prosecutor's Office. If there will come up a need for them to postpone that period of time, or to set another limit, they could file a submission, file a request to Your Honor for extending that time period. But it keeps the pressure also in that case regarding the detention and remand, giving them the whole period on advance. There is also pressure felt by the SPO, but it needs to be more strict as far as the defense is concerned. And if there's some issue to be raised, then the Special Prosecutor could turn themselves to you, asking for either one solution coming up at that time. But a more strict time limit has the definite favor of the defense. Thank you.
Thank you, Mr. Sitema. Madam Prosecutor, on this very interesting proposal by the defense of having a deadline that would be, for example, on Friday, 15 December, provided that it could be extended, would you get evidence from investigations that you would continue in the following weeks? Does it seem like a deadline that is possible for you?
I think it's certainly possible to, again, just as we did with the 102(1)(a disclosure, agree to make a rolling production here. That said, I would just remind everybody that we do have an ongoing investigation that I have estimated will take at least 3 months. So I think, having set a deadline that is approximately 3.5 months out per my colleague's calculation is pretty aggressive. We are trying very hard to get this information to the defense in a timely fashion. And again, I would just emphasize that as information comes in, even the information we have now is subject to several additional processes before it can be disclosed in some cases, right? We're talking about redactions, often in more than one language. We're talking about transcription, about translation, all in addition to the ongoing review process. That said, being prepared to commit to a rolling basis, if Your Honor were to set a specific date of 15 December, as certainly by that date, some form of disclosure under this rule will have to have been made by the Specialist Prosecutor's Office. I have no objection to committing to that.
Thank you, Madam Prosecutor. This is noted. Now let us move to the next item on our agenda today, which is the evidence material to the defense preparation, which is the Rule 102.3 material. I would like to remind the SPU that disclosure or inspection of evidence such as statements, documents, photographs, or tangible objects material to the defense must be disclosed without delay. The detailed notice of such material must include not only information the SPO assesses to be potentially material to the defense preparation, but any material and evidence in the SPO's possession which has not been disclosed under Rule 1021A and B and 103, and which is relevant to the case. And I invite the parties to review the jurisprudence of the KSC on this legal question. I also remind the parties that disputes as to the materiality of the information as claimed by the defense must be submitted immediately to the pretrial judge for resolution. I take note that the SPO anticipates providing the defense with a detailed notice of Rule 1023 material by 23 February 2024. I also take note that the SPO requests a time period of 2 weeks to file materiality challenges to material identified by the defense. So I invite the SPO to indicate for this category an estimation of the type and amount of material, the redactions that will be required, and any other detail that the SPO wishes to provide. Madam Prosecutor, you have the floor.
Your Honor, the SPO anticipates that the Rule 1023 review that will be undertaken will depend in large amount to the process we engage in as far as our 1021B review goes. Ultimately, what will be produced under 1023 to the defense is going to consist in large part of residual material, and therefore would consist of the same categories of documentary evidence that I've already outlined, namely call data records, and in particular, under 1023, the full contents of mobile phones that have been seized from the accused and from the individual named co-perpetrator 1 in the confirmed indictment. And to that end, I will note that actually the Specialist Prosecutor's Office intends to make a disclosure of the full images of those mobile devices to the defense on the same timeline that it is producing the very first disclosure it will be making under 1021A. And so we are fully cognizant of the importance of certain of this evidence to the defense's review from the beginning, and so those materials will be made speedily available to the defense. As to the rest, not knowing as of yet, given where we are with the investigation, the full volume of materials that we will be dealing with and what will be residual after our pending 1021B analysis, it did seem reasonable to the Specialist Prosecutor's Office to set that February deadline, having in consideration of the January deadline we proposed for the 1021B materials.
And if the January proposed deadline becomes a December deadline for the 1021B, what could we anticipate for the Rule 1023 list of 1023 material?
Your Honor, I think as with the previous categories, we would certainly be willing to engage in disclosure on a rolling basis. As I've noticed, the mobile phone evidence will be going over, well in advance of certain of these deadlines, late this month, early November, as soon as is practicable for us to turn it over. And so I think having a final deadline of what we have proposed in 23rd February, I believe, would be entirely reasonable given what we may be up against as a Specialist Prosecutor's Office, but certainly we could make disclosures pursuant to 1023 earlier as well on a rolling basis.
The problem is that you need to provide the defense with a list of material. So
I'm sorry, yes,
the
of
rolling
course, the
basis,
list.
I understand, but this would be for after the deadline you propose. But the difficulty I see is that the later the list is provided to the defense, if we had the time for the defense to review the list, then the 2 weeks that you request to be able to reply to the defense, then the materiality challenge before me, this is an extra probably months or months and a half. We're looking at April, and if the defense asks me to make investigations based on the documents that you will have disclosed under 1023, we're already in May. So I find that it is a bit long for a case like this. This is why I am insisting on having the possibility to have the notice before the end of February.
Yes, Your Honor. With certainly, we are not looking to push things out, without due cause. I believe that we should be able to get at least preliminary 1023 list to the defense at the end of January, and would ask that we be allowed to supplement that list as needed.
Thank you, Madam Prosecutor. Much appreciated. Mr. Gillis, please.
Thank you, Your Honor. I only had one remark, but the remark has already been shortened by the question you asked. There is a clear connection between 1021B and 1023. And then the logic question is, of course, if the 1021B delay would be 15th of December, then the defense asked very clearly to bring it down, of course, the 23rd of February, of course, bringing it down, of course. Of course, sometimes I forget by talking about the dates. In the law, of course, 1023 says, is the second time I say it, it will be the last time, without delay. There's a too much gap to be reasonable and acceptable, because specialist prosecutors say, for us it's still entirely reasonable, the delay that is now foreseen. For the defense, it's not. There's a big difference between without delay and then almost 4 months and a half. But our main argument from the defense from Mr. Januzi, Your Honor, is of course the connection between 1021B and 1023. And of course, if Your Honor makes a decision concerning 1021B in the direction of 15th of December, I ask to be a logic there, and then of course straightforward, and have a far shorter delay for 1023. And once again, I finish with that. I refer to the submission from the Special Prosecutor's Office, margin 21. That is very clear, where it says it's a limited case, not extremely limited, relatively limited case, but also in the content of the evidence that will be presented. So that is what I had to say. Thank you, Your Honor.
Thank you, Mr. Gillis. Mr. Sitema, please.
Thank you, Your Honor. I've little to add on what has been said, both by you, Your Honor, and my colleague on this subject. I think we made very clear that as a defense we have a clear interest, there's a clear importance of disclosure of any material, also this material, or lists that go along with it. Thank you.
Thank you, Mr. Sitema. Let us now move to the rule, unless, Madam Prosecutor, you want to add something? Let us move to the Rule 103 material, which is the exculpatory material. I remind the SPO that it must disclose immediately to the defense any exculpatory evidence as soon as it is in its custody, control, or actual knowledge, and which may reasonably suggest the accused innocence or mitigate the guilt of the accused or affect the credibility or reliability of the SPO's evidence. Disclosure of exculpatory evidence is a continuous obligation, subject only to protective measures where necessary. I note that the SPO is continuing its review of Rule 103 material within its custody, control, or actual knowledge. So, as for the other category of material, I will ask you, Madam Prosecutor, to indicate the amount and type of exculpatory material the defense can anticipate, whether redactions will be required, and if there are any other details you would like to provide. Madam Prosecutor, please.
Currently, Your Honor, the SPO has not identified any material under Rule 103. Our review, as we noted in our submission, is ongoing. That said, we are very mindful of our obligations under Rule 103 and will certainly make immediate disclosures of any such material upon its discovery.
Thank you, Madam Prosecutor. Does the defense want to mention anything on this?
No, Your Honor.
Thank you very much. Let us now move to the protected material, which is the 107 material. I take note that at the current stage, the material that the SPO intends to disclose pursuant to the rules, do not require Rule 107 clearances. Madam Prosecutor, do you want to add anything to your written submissions on this point?
I would just state once again, the investigation is ongoing. There is information flowing in as a result, and to the extent that any such material would be subject to Rule 107 clearance, we would certainly promptly inform Your Honor and proceed accordingly.
Thank you, Madam Prosecutor. I turn to the defense. Do you want to add anything on this point?
No, thank you, Your Honor.
No, thank you, Your Honor.
Thank you, counsels. Let us now move to the procedure for disclosure, notably the use of the case-specific categorization in legal workflow for material falling under Rule 102.1a and b, and Rule 104.1, 5, and 6 at the time of disclosure of each batch of such material. In its submission, the SPO contends that the proposed categorization would both delay the disclosure process and, I quote, potentially cause confusion during the review process. I invite the SPO to indicate why the categorization of evidence by counts or by accused would cause confusion. I was a bit surprised when I read your written submissions, to be honest. And if the SPO is not available to indicate which piece of evidence supports each count or if each mode of liability, then I don't really understand how you will plead your case, Madam Prosecutor. The SPO also submits that it would be nevertheless in favor of a mutual agreement with the defense should this find the proposed subcategorization of assistance. As regard the defense, I take note that the defense, both for Mr. Januzi and Mr. Bahtjari, are in favor of the proposed disclosure procedure. So I invite the parties to give further detail on this topic, notably whether the parties wishes to make any proposal as to further subcategories to be added, whether the parties can agree on a model of consolidated disclosure chart that satisfy the requirements of Rule 109C of the rules, and whether the SPO and the defense agree to provide each other with a consolidated disclosure chart at the time of the submission of the SPO pretrial brief and the defense pretrial brief, respectively. Madam Prosecutor.
The Specialist Prosecutor's Office position that additional subcategorization of the items to be disclosed is unnecessary here is based largely on our review of items already in our possession, including the indictment supporting materials that Your Honor is aware of. It seems to the office that there are many items, if not most items, that would end up getting tagged with the all category or most of the other categories, such that the meaning of these additional categories would essentially collapse in on itself. And you know, despite that being the case, consideration of which categories do apply to each individual item would nevertheless be a time-consuming process that may involve the multiple resources, multiple individuals' input, and in that sense would delay the disclosure. And on the back end, it occurs to me that if what the defense were to receive is a categorization that essentially checks all the boxes for most materials, it could cause confusion, or at the very least would not be of any additional assistance than the more standard categorization framework. And so our proposal would be not to apply the additional subcategories, but of course we are open to discussion with the defense regarding categories that they would find helpful, and coming up with a mutually agreed framework in that regard, and similarly would agree to both provide and be provided with a consolidated disclosure chart within some distance of time. We propose 15 days of any pretrial filing, which we think would be of help to the parties involved. And so that would be the reason for our position, Your Honor.
Thank you, Madam Prosecutor. Before I give the floor to the defense, let me put this debate in context. I've had long discussions with the SPO on the issue of categorization of evidence in past cases, because I've always considered that it was a duty for the bench to organize the evidence so that it would be clearer not only for the judges but also for the defense, for the understanding of the case, and it will also facilitate the work of all parties and thus speed up the proceedings. So this is the reason why I asked for this categorization. And before I give the floor to the defense, maybe one question to the prosecution. The fact that the categorization would in fact not be pertinent because it would apply to, in fact, you would tag all documents with any category. Is it true for the counts, or is it also true for the modes of liability and for the two names of the two accused? Because I can understand what you say vis-à-vis the counts, but the modes of liability I have more questions, and the two accused I have even more questions.
I think, Your Honor, that it would also apply to the modes of liability, possibly to a lesser extent, but certainly many overlapping modes involved as far as what the Specialist Prosecutor's Office alleges. And I think perhaps to an even lesser extent to the accused, but again, one of the allegations here is that the accused worked together in a group. And so given the nature of the charges, I think in that case also, there would be quite a bit of overlap, which again, in our view, to diminishing value in terms of the use of the subcategories, excuse me.
Thank you, Madam Prosecutor. Mr. Gillis, please.
Thank you, Your Honor. To be honest, since one day, I've been thinking about this part of the submission. For the defense of Mr. Januzi, not going along with the standard rules of procedure and evidence would for us, we have to be presented with an argument that really makes it tangible. And indeed, as Your Honor already noticed, the main question I have is, we're not following specifically here the rules of procedure and evidence, and the categorization would mean that that there would be confusion. I don't see it directly. Of course, I've been listening to what the special prosecutor answered, but I don't see it legally in this case, bearing in mind, once again, the relatively limited volume of material and also, of course, the nature of the disclosed material. And then secondly, how also this would delay the disclosure process. I don't see it directly. Of course, Your Honor, you will with all the experience make a decision there, but the defense, after one day, sometimes one day is not enough to think over things. But I think we've done also, my colleague counsel, I've been really thinking about that, and first argument, the defense of Mr. Januzi, Your Honor, says that for us, I don't see it. And I think if indeed in this case there is no specific reason that we can see in the file and that can be argumented, I think that following the rules of the categorization, following the standard rules of procedure and evidence, should be the norm. Should be the norm. Having said this, of course, looking for mutual agreement on that, of course, we're willing to do that, of course. But then it has to be a mutual agreement, and sometimes it's not that easy. You don't want to lose time there either. And that is the difficult decision, Your Honor, you have to make. But our main point of view, looking at it, is that we don't see a specific grounded reason to depart from the rules of standard procedure and evidence in this case. In this case, bearing in mind for sure that categorization in this case should not take ages, I think. And it's very important, I think, looking forward to where we'll end up and the trial itself, I think it will be very important. But a mutual agreement should be possible, but I think the defense is clear with what we ask, Your Honor.
Thank you, Mr. Gillis. Mr. Sitema, please.
Thank you, Your Honor. I agree with my colleague, Mr. Gillis. If what I hear from the side from the prosecution's office is that, and that's my summarization of it, that there is an overlap and there is a connection between the charges, and it's one complex of facts, that it leads to a categorization like we have to check all the boxes. Well, wouldn't that be easy? So where's the profit of seeking another framework that's different from the standard framework? So I can understand the questions raised by yourself, Your Honor. But also, on the other hand, it's in our interest to make things work easy and quick for our work for our defendants, for our clients. So the defense of Mr. Bahtjari is also open for any agreement discussion on these topics. But first, we would ask you to stick to the framework you suggested. Thank you.
Thank you, Mr. Sitema. Madam Prosecutor, do you want to mention something?
I believe I've already addressed some of what my colleagues have raised. I do want to clarify one thing, though. We are certainly not looking to divert from what the rules provide for. We would certainly still mark all items consistent with the main categories called for by the rules. Our response is it was limited to the subcategories provided by Your Honor in order to further clarify and aid the defense in its review of the evidence. And our position is simply that we don't actually think that the subcategories as applied to our evidence would be helpful in that regard. But again, in terms of mutual agreement on categories that would be helpful, we are certainly open to that conversation.
Thank you, Madam Prosecutor. I don't see any requests for the floor. So let us now move to the redaction regime. I remind the parties that in adopting a redaction regime, it is necessary to ensure the efficiency of the disclosure process while striking a balance between the duty to protect the interests of the victims and witnesses and upholding the rights of the accused. In their submissions, the SPO and the defense agreed to adopt the redaction regime applied in case KSC-BC-2020-04. I invite the SPO and the defense to make any further submissions on this topic. Madam Prosecutor.
Thank you, Your Honor. As a general matter, the Specialist Prosecutor's Office agrees to adopting the redaction regime that is outlined in the framework decision for Case 4. I would just note that with regard to the default timeline to file materiality charges, the office has found the 5 days to be unmanageable and would request 2 weeks consistent with protective measures in the same context. Thank you.
Thank you, Madam Prosecutor. Mr. Gillis, please.
Your Honor, I don't have any remarks on this subject.
Thank you, Mr. Gillis. Mr. Sitema, please.
The same goes for the defense of Mr. Bahtjari. Thank you.
Thank you, Mr. Sitema. There is one other point I would like us to discuss today that was not on the agenda, but the SPO raised it in its written submissions. It is the question of the adoption of a protocol on handling confidential information and protocol governing the protocol of handling confidential information and contact with witnesses of the opposing party. This is a protocol that I have adopted in other cases. Madam Prosecutor, can you expand on this? What would be the need? And would it be efficient if such a protocol was annexed to my framework decision on disclosure of evidence?
Thank you, Your Honor. Yes, the Specialist Prosecutor's Office intends to make a submission in short order to address the confidentiality of information as well as contacts with witnesses. Such provisions have been made in former cases, as Your Honor is well aware. In this case in particular, It is of immense importance given the nature of the charges at issue here and of the alleged conduct, which involves the approach by the accused made to an individual whom they believe to be connected with proceedings underway here before the chambers, and the way in which it was made. I don't particularly wish to go say anything further on the record today. We will be following up with a written submission that will, of course, be accessible to all in the courtroom today. And I think it actually would be helpful for Your Honor to incorporate that into the framework decision that is forthcoming.
Madam Prosecutor, do you request any changes in the protocol that I have adopted in other cases before the KSC, or would it be the same protocol that I adopted before?
It would be largely the same, but there is a significant modification that we would request with regard to the contact protocol, which I'm happy to expand upon in my written submission. But basically, we would ask that contact limitations be applied not just to the individual identified as witness one in the confirmed indictment, but also to family members.
Apart from that, it would be the same regime as the protocol I've already adopted in other cases.
Yes, Your Honor.
I'm trying to find the most efficient way, because if I want to annex it to my framework decision on disclosure of evidence, I need submissions from the parties very soon. Would it be possible for both the SPO and the defense to file submissions on this protocol by, I don't know, Monday next week, for example, or Tuesday next week? It means that for the defense, it's a question of reviewing the protocol that I've issued in other cases, which is actually the same as the protocol in the annex of the Chambers Manual of the ICC, so it's nothing that is very different from common practice. Is it something that is feasible for the prosecution and the defense? And you can take 30 seconds or a minute to think about it or discuss with your colleagues if needed. Madam Prosecutor?
Yes, Your Honor, certainly possible from the specialist prosecutor's side.
Thank you, Madam Prosecutor. Mr. Gillis.
Yes, Your Honor. Two remarks. First of all, we eagerly await the submission of the Special Prosecutor's Office. We want to read it, of course, and then maybe we don't have any remarks, then it will be a very short submission. But we absolutely want that. Secondly, Your Honor, Monday is really not possible. For me, I think for my colleague, I propose, the defense of Mr. Januzi proposes Wednesday by 12 o'clock noon. Again, like, by the way, yesterday was also 12 o'clock noon. By then, of course, we will have the submission. We will have directly, directly study it and evaluate. But we respectfully ask Your Honor to make a decision on that. That first of all we have the submission, and secondly that the delay would be Wednesday at noon instead of Monday. That's really almost impossible for the defense of Mr. Januzi. Thank you, Your Honor.
Thank you, Mr. Gillis. Mr. Sitema, please.
Thank you, Your Honor. The same goes for the defense of Mr. Bahtjari. I think it's wise that we await the submission of the Special Prosecutor's Office so that we can react on that. And maybe that's a very plain and simple reaction, that we have no comments on it. And if we do, we will do so. But the order of things would be most practical in that way. Also for me, it applies that I couldn't file a submission by coming Monday due to my other obligations, amongst which visiting my client tomorrow. Thank you.
So if we have the submissions of the SPO on Monday and the response of the defense on Wednesday, would this be agreeable to all of you, Madam Prosecutor?
Yes, Your Honor. Certainly, the Specialist Prosecutor's Office could make its submission on Monday. If I might clarify one point, Your Honor had asked regarding what modifications we might be proposing in our submission. So I wanted to clarify, in addition to the expansion of the contact protocol, there would be an additional modification regarding the mode of testimony and specifically pre and post testimony contact, which I could expand upon in the submission, but just so that it was noticed today here in court.
Thank you, Madam Prosecutor. Mr. Gillis?
Your Honor, that we agree, of course.
Thank you, Mr. Gillis. Mr. Sitema?
Same goes for the defense of Mr. Bahtjari. Thank you.
Thank you, Mr. Sitema. I will issue an oral order on this in a couple of minutes. Before I issue the oral order, at this point, do the parties have any issues they would like to raise today? Madam Prosecutor.
Yes, Your Honor, something small and something I had hoped to discuss with counsel for Mr. Januzi before we got started today, but it is my understanding that Mr. Januzi may prefer to use an alternate spelling of his name in these proceedings, and if that is the case, just something I wanted to get on the record in terms of clearing that up so that we could use the preferred spelling going forward.
Thank you, Madam Prosecutor. Mr. Gillis, do you have any submissions on this point?
Not directly. We will address that and then take contact, of course, with the prosecutor's office. Thank you, Your Honor.
Thank you, Mr. Gillis. Madam Prosecutor, anything else?
No, Your Honor, thank you.
Mr. Gillis, anything else you would like to raise today?
Your Honor, of course, we submitted we have a second submission on the detention on remand, and of course, as for now, I don't know whether Your Honor asked us to give any oral arguments on that. I'm ready, of course, to do that, but it's not clear for me if Your Honor you expect me to do that right now. I don't think so. I had understood of no.
No, it will be done by written rulings,
Yeah.
and you will have also access to a certain number of decisions that will be disclosed to you, I think this afternoon or tomorrow at the latest. So feel free to supplement your submissions if needed with the decisions or evidence that will have been disclosed to you.
I understood that, Your Honor, but just because you asked me if I have any remarks, that was a remark. Thank you.
Thank you, Mr. Gillis. Mr. Sitema, please.
Thank you, Your Honor. Exactly this point was raised before the start of the case with the prosecution. They suggested that we added supplements to the submissions we already made, considering what we know now, rather than we did yesterday filing the submission. So we gladly would take the opportunity to do so, and then the prosecution, special prosecution, can react on that. So thank you for that.
Thank you, Mr. Sitema. Would you supplement your submissions on detention of remand, for both defense teams? If you can just inform the SPO so that they do not make a response, for example, while you are at the same time filing supplementary submissions, because that way it would avoid a bit of confusion between the filings on both sides, and it will also clarify the briefing schedule.
Of course, we will do that, and I'm talking for Mr. Gillis on this point also, I guess.
Thank you very much. I don't see that the parties request the floor, so I would like to inform the parties that I intend to hold the second status conference on 3rd November 2023, most likely in the morning. I note in this regard that should counsel of the accused wish to participate via video conference, written notice shall be sent to the registry via email 24 in advance, so that arrangements can be made, and such notice should also include the written consent of the accused, as I mentioned during the initial appearance. I will also indicate that you will receive a scheduling order for the next status conference that will include the agenda. If you wish to address other issues at the status conference, please indicate this in your written submissions ahead of the status conference so that the other party can be briefed and so we can have efficient and productive hearings. I will now ask you to wait for a couple of seconds, the time for me to finalize the oral order, and I will issue it in a couple of seconds, but you can stay in the courtroom. So we're going to break for 5 minutes, and then I will come back with the oral orders. Just before we break, to make sure that the parties do not have anything else to add. No, I don't see requests for the floor. Okay, so we break for 5 minutes, and we'll be back in the courtroom very soon.
All rise. All rise. Please be seated.
So I will now issue my first oral order concerning the adoption of the protocol on handling confidential information, adoption of protocols governing the handling I will issue my first oral order concerning the adoption of the protocol on handling confidential information. And I instruct the SPO to file its submission by Monday, 16 October 2023, and the defense is instructed to respond by Wednesday, 18 October 2023. No reply will be entertained, and this concludes my first oral order. And this concludes the status conference today. I thank the parties and participants for their participation. As usual, I thank the interpreter, audiovisual technician, stenographer, and security personnel for their assistance. The hearing is adjourned.
All rise.